Artificial intelligence bias in hiring, the one nobody gets to ignore. Of every place artificial intelligence bias could go wrong, hiring is the one with nowhere to hide. It's not an abstract fairness debate happening somewhere in a research paper. It's a real person with a real name, applying for a real job, getting rejected by a system nobody in that building fully understands, for reasons nobody in that building is required to explain. So let's go through 4 times this has already happened, properly documented, real names, real numbers, and in one case, a lawsuit that is not finished yet. Case 1, and you may already know the shape of this one, because it's become the textbook example for a reason. A major retailer built an internal tool to screen incoming resumes trained on roughly a decade of the company's own hiring history. The tool taught itself that resumes were less promising if they included the word women's, as in women's chess club or women's football team, because the historical data it learned from came from a period when the company had mostly hired men. It wasn't told to penalize women. Nobody wrote that rule. It found the pattern entirely on its own, in data the company itself had generated, and applied it with total consistency. The company caught it internally and scrapped the tool before it caused more damage than it already had. Credit where it's due for catching it. No credit at all for how it got built in the first place. Case 2, 2023, an online tutoring company, and this time it's not an internal catch, it's a government settlement. Company's hiring software was found to be automatically rejecting female applicants over the age of 55 and male applicants over the age of 60 the moment their date of birth entered the system. Over 200 applicants were filtered out in a single year purely on age. Here's how it got caught, and I want you to sit with this for a second, because it's almost funny if it wasn't so serious. One rejected applicant submitted a second application, identical in every way except one: a younger birth date. That second application got an interview. Same person, same qualifications, same everything except a number. He later settled the case for $365,000, and it stands as the first ever settlement of its kind. An actual government body confirming that an algorithm did the discriminating and the company that deployed it was still on the hook. Case 3. And this one's interesting for a different reason, because it's a story about a company that got caught, listened, and pulled the plug themselves, which is rarer than it should be. A well-known video interview platform built a system that analyzed candidates' facial expressions during recorded interviews, scoring things like engagement and enthusiasm based on how your face moved on camera. Researchers and privacy campaigners spent years pointing out the obvious problem, that facial expression doesn't mean the same thing across every culture, every disability, every neurotype, and that scoring people on it risked discriminating against exactly the candidates least able to perform a normal expression on demand. A regulatory complaint and an independent audit later, the company dropped the facial analysis entirely. And here's the detail that should really sting if you're the one who approved a tool like this. Their own internal research found the facial data was adding something like 0.25% to the tool's actual predictive accuracy. 0.25% for a feature that carried real, documented discrimination risk against disabled and neurodivergent candidates. That is not a trade-off. That is a company that took on serious legal and ethical exposure in exchange for almost nothing. Case 4, and this is the one I want you to pay closest attention to because it isn't finished. It's happening right now while you're watching this. A man applied to over 100 jobs at companies that all happen to use the same third-party artificial intelligence screening tool between 2017 and 2024. He was rejected every single time. Every one. He's a black man over 40 who has been open about living with anxiety and depression, and his lawsuit alleges the screening tool discriminated against him on the basis of race, age, and disability. All three, all at once. Here's the part that should genuinely worry every company reading this. The court didn't just say the employers might be liable. It said the artificial intelligence vendor itself could be directly liable as what the ruling called an agent of the companies using its product. In the middle of 2025, The case was certified to proceed as a collective action, meaning anyone over 40 rejected through that same tool since 2020 can now join. One rejected applicant became potentially thousands. 4 cases: a retailer that caught its own mistake, a tutoring company that got fined for one it didn't, a video platform that dropped a feature worth almost nothing the moment the true cost became clear, and a vendor currently finding out in open court that we just built the tool, we didn't make the decision, is not in fact a legal shield. Notice what's actually consistent across all 4. Not one of these was a hacker breaking in. Not one involved anyone trying to cause harm. Every single one was a system doing precisely what it was built and trained to do, at scale, on autopilot, until either an internal audit, a government regulator, a journalist, or a rejected applicant with a second birth date happened to notice. This is exactly why an artificial intelligence management system doesn't treat who's affected by this decision as a nice-to-have footnote. It's why impact assessments exist before go live, not after a lawsuit. It's why data governance means someone is accountable for knowing what your training history actually contains, rather than assuming 10 years of hiring data is neutral just because nobody labeled it biased on the way in. And it's why the supplier relationship itself is now a genuine legal exposure, not just a procurement line item, because apparently a court will now ask your vendor the same hard questions it asks you. I'm not a certified lead auditor, and I'm certainly not a lawyer, so don't take legal advice from a man narrating a Lovecraftian monster metaphor earlier this week, but you don't need either qualification to understand this much. If your hiring pipeline includes any automated screening at all, and increasingly almost everyone's does, the vendor said it was fine, stopped being a defense somewhere around case number 2 on this list. So here's the dare. Before Friday, find out exactly one thing, not whether your hiring tool is biased, because nobody can honestly promise you that in 5 minutes. Find out whether anyone has ever actually checked. Pulled the outcomes, broken them down by age, by gender, by race, and looked on purpose for a pattern nobody meant to put there. If the answer is no, you don't currently have a hiring process. You have a guess wearing a very expensive suit, and 4 real cases this year alone say that guess doesn't hold up in court.